My lord, this is a criminal revision petition, my lord. It may be listed for admission on Friday, my lord. Matter relates to maintenance, ma'am.
Not on Friday. On 9 December.
Similar prayer, Lordship, on 9th or 8th, on two petition, Lordship. One is criminal petition and 1/9 and 1/10.
May I please, your lordship? Lordship, I beg to mention one criminal appeal for listing on 8th of December. It has not been listed.
May I please, your lordship? I'm praying for a listing of a criminal petition. Can you kindly come on Friday, lordship?
Not on Friday, not this week. On 10 December. 10 December.
Obliged.
May I please, my lord, I have filed a bail application, my lord. It is urgent, my lord. So kindly listed me tomorrow, my lord. Bail application, my lord.
It is more than 7 years. Less than 7 years. Offense is more
Less than NDPS Act, my lord.
Oh,
Commercial
alright.
code.
When do you want?
21C, my lord. 22C section.
When do you want?
Oh, tomorrow, my lord.
No, finally. Day after tomorrow?
Side 4 December, my lord. Highly obliged, my lord.
Similar prayer lordship, more than 10 years, 7 years. Bail application. Tomorrow or day after tomorrow.
May I please your lordship? Item 19 to 22, respondent advocate has some problem. So
19 to
she's,
20. Just a moment.
she is unable to appear before the honorable court today. So listed listed this case after 12 December.
Have you taken consent from the other side?
Yes,
Yeah.
but can it be fixed on 17th
17,
of this month?
19 to 22. Everybody is agreeable to 17.
Yes. Petitioners are the same parties.
Learned Counsel, Miss, your name?
Chetamuli.
JW. Your name is in the cause list, no?
No,
On behalf of Learned Counsel, Mr.
on the Shekya. Yes, yeah.
Mr. or Miss?
Miss.
Miss
Oh, no,
A.
Mrs.
Mrs. A. Sulkia, representing the respondent.
Yes.
Representing the respondent. Has, with the consent of the other side, has prayed for adjournment. List the matter on 17 December.
Obliged, George.
May I please, your lordship? Lordship, in item number 37, we have filed an additional affidavit as per the order of this honorable court. And same may be called for lordship and today. And item number 15 is similar matter, lordship. Both may be taken up.
15.
May I pay the lordship? I beg to mention item number 36, lordship. This matter, I may be allowed to withdraw this petition, lordship.
Well, ticket number, what is it?
36.
After the case.
Criminal petition, lordship. The matter relates to quashing of FIR, but charge sheet has been submitted, so I may allow to withdraw.
Learned Counsel, Mr.
U.S. Borgohain.
Buragohain. Yes,
Borgohain.
Has prayed for withdrawal of this application. Learned additional PP.
I am for private respondent. M. Pathak.
Learned Counsel, Mr. M. Pathak is present for the private respondent, and learned additional PP, Mr. B. Sharma, okay? Is present for the state. Petition is dismissed on withdrawal.
Obliged, lordship.
36 withdraw করি আছে, কোনো 15
May I please, your lordship? I beg to,
I've given your name, okay? In the criminal petition.
may I please, your lordship? I beg to mention item number 25 to 31, lordship, the serious matter, lordship. Kindly adjourn for the day, lordship.
For the day.
For the day, lordship, adjourn for the day.
Next.
Kindly, the date may be fixed on after vacation, lordship.
It's a long pending cases.
B. Goswami.
Cases.
B. Goswami.
B. Goswami is present for the appellant, and learned standing counsel. For the CBI, Ms. M. Kumari is present. This stop. On a request, item number
25 to 31.
25 to 31. On a request, for the appellants, 25 to 31.
Yes, lordship.
Since it is not long pending, my objection may kindly be recorded, your lords.
Request for the appellants, list this matter is passed over for the day. On a request by the appellants, list matter is passed over for the date. Under objection by the Learned Standing Council, as this is a long pending case.
Next, after vacation, lordship kindly.
Pass over the day. You have stated pass over for the day.
The kindly please have a-
No, lordship, actually, the date may be fixed as
As
Of
this
like-
is a long pending matter, list this matter on 8 January.
much.
May I please your lordship, I'm praying for listing criminal petition for tomorrow.
No,
Matter is, matter is this, fixed one yesterday, but do you technical or it is not listed?
10 December.
Lordship, it is yesterday
No,
already
I
fixed.
won't be able to take up this. Or not tomorrow.
5 lordship.
10 December.
Five.
9 December.
Another bail application. Lordship, pray for listing.
May I pray for listing of an anticipatory bail application, your lordship, either tomorrow or day after tomorrow, your lordship. Anticipatory bail application now, and
Type of,
lordship,
offense.
there is some,
More than 10 years.
lordship,
Not fine.
7 years, your lordship, 7 years,
7.
up to 7 years, your
Oh,
lordship.
no, not before this court then.
Lordship,
Up to 7 years, it will be another court. Just inform court.
I'm told that this,
No, up to 7. Court number 3.
oblige, your lordship.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 13, lordship. Lordship, conducting counsel, Mr. P. Bojumdar has some personal difficulty, lordship.
Item number 13.
Kindly adjourn for the day, lordship.
Your name?
R. Dev.
Learned Counsel Miss R. Dev on behalf of Learned Counsel Mr. P. Mozumdar.
Lordship,
As
kindly
paid
fix
for
the date,
adjourn.
lordship.
Huh?
Kindly fix the date, lordship.
This
Monday,
matter when do you want?
Monday,
Yeah, not mine. 11 December.
oblige, lordship.
May I please, lordship, I will mention for 2 criminal petition, listing for admission. For December.
11 December. 2 criminal petitions.
Maybe it's a lordship, item number 16, 116, madam. Pass over the matter for this day, madam. Fix on Monday, madam.
Your name?
A Khalek.
Learned Counsel Mr. A. Khaled, on behalf of Learned Counsel Mr.
AZ Ahmed. AZ Ahmed.
AZ Ahmed has paid for adjournment, list the matter on 11 December.
Oblige, madam.
Item number 4 and 5, motion.
May I please your lordship?
Mm.
This criminal leave petition is filed against the judgment and order of acquittal passed by the additional CJM Kamrup Mingaon, illegally acquitting the accused without considering the materials on record, evidence, oral and documentary, and did not consider any aspect, simply
You will admit it, acquittal, for acquittal.
acquittal. So this is the criminal leave petition?
Will grant the leave,
Yes. That's it.
okay? Will grant the leave?
Formal party. We have formal party.
Yes.
I can demand.
Four.
Item 4, we are not the party also, madam.
No, no, you are party. Respondent number 2.
But it is not shown in the cause list.
May not be, a copy has been served.
No.
Yes.
Actually, the leave petition is between the court and the appellant. That,
Anyway,
so we have nothing.
since you are a party,
Let us issue notice, this civil type of matter, we'll issue notice, then we will admit it. Because
No.
this appears to be a type of civil nature, matter of civil nature.
no, it is of criminal nature, not of
I
civil.
understand, but then we'll let us issue notice to the respondent. Let us issue notice to the respondent.
Yes,
He is the accused. Without hearing, it will not be good because it appears to be a nature, matter of.
it is up to your lordship. But
Land dispute.
there is illegality, totally illegality,
Let us
none
issue
considered
notice. Issue notice. We have to hear him.
to the respondent number 1.
Accused has always to be heard. একটু লিখাচোন ক্রিমিনাল এলপি লিখি দিয়ে টাইপটো একো লিখিব নালাগে হা এডমিট হোৱা নাই লাৰ্ণাৰ কাউন্সিল মিষ্টাৰ এছ ভূমি
I am RPC.
লাৰ্ণাৰ কাউন্সিল মিষ্টাৰ
RPC, she is my junior, yes.
Mr. PC is present for the leave for the petitioner who has prayed for leave. Pray. To before an appeal against the judgment and order dated 26/9/2025 of acquittal passed by Learned Additional CJ in connection with complaint case number 43/2023. 43 stroke. Issue notice to the respondent number 2, Learned Additional People, Mr. MP Hussain is present for the respondent's and has accepted notice. Full stop, extra copies to be furnished. Issue notice to returnable within 4 weeks. List accordingly, 4 weeks,
Pardon?
4 weeks. After 4 weeks.
Item 6.
But this is a revision against the order of conviction upheld by the land court below. That is 1 year conviction, my lord. So I pray that it may be admitted, but under 4 of the second prize money, there is a penalty of 22,000 and SI for 1 year. My lord. Pardon?
You are on previous bail,
Beg your pardon?
you are on bail.
Yes, I have been released on bail.
Yes.
Court below has released me
Which
on
was the
bail.
proceeding?
Plus
1 year.
What?
none.
Learned Council, Mr. S.C. Biswas is present for. Applicant who has filed his application under section 430 of the BNSS 2023, read with section 438 of the BNSS with prayer for bail during the pendency of the connected appeal as well as suspension of sentence. To stop.
Your lordship have to suspend both the order. Trial court as well as this, yes.
But that order has been upheld.
Yes, yes. Where is the order?
By judgment and order dated, like judgment and order dated 21/12/2024 in PRC case number 158 stroke 2022, the appellant stroke applicant was convicted. Section 420 IPC. No, 420, under section 4 of
The price sheets and money circulation,
420 IPC number, section
Yeah.
4 of the price PRS any cheap.
money circulation schemes.
Yes, cheap money circulation schemes. Within bracket banning. bracket
Act 1978.
Nineteen 78. And sentenced to simple imprisonment for 1 year and final rupees 2,000 with default stipulation. And by judgment and order dated 3/11/2025. In criminal appeal number 151 of 2020, this order of the Illinois trial court has been upheld by the appellate court. The appellant is already on previous bail.
No, one thing,
No, not previous bail.
not on previous.
NBW has been.
He is directed to surrender.
Surrender.
So he is not on previous bill,
Not previous.
not previous bill.
That was an answer. That's why I filed my IA, my lord. I filed IA. 1276.
Because
1 year your lordship can grant, my lord.
I will get, just a moment, we'll give you, we'll pass an order for fresh bail then.
Yes, I have to, I have to.
yes, yes.
Hard Mr. MP, hard Mr. MP. Sessions.
I have filed my IA.
Paid for previous bill will examine. The appellant has paid for bail and for suspension of the, for suspension of the sentence. Full stop. Hard Mr. MP, this one will have additional. Full stop. I have considered the submission to the bar. Full stop. Considering all aspects, the appellant stroke applicant is granted bail of rupees 10,000 with a suitable surety of life amount with the satisfaction of the learned
Trial court.
trial court,
Yes.
who may also impose conditions if the court deems fit and appropriate to stop. Meanwhile, call for the original records from the learned trial court as well as the learned appellate court
But IA is disposed of, I think.
in terms of the above order, which can this I stands discussed.
Diplo applies.
Main question लिखिएगा आज Mr. Services learned counsel for the petitioner and Mr. MP Vishwanu nomination details. Did you notice to the respondent?
Yes,
Number 2,
yes.
it's returnable within 4 weeks. Call for the record.
LCR, madam.
Call for the trial court records, original records are from the learned trial court as well as the learned appellate court. List according to.
May I please, your lordship? Here, lordship, what has happened was a negotiable instrument act case, lordship. Past trial court, overlooking the fact that there is no legally enforceable debt, lordship, punish me for 1 year and to pay a fine of rupees 1,30,000. The appellate court has upheld this order. So this revision is filed, lordship, may kindly see, is now 22 for a moment, lordship. Page 22. Everything will be clear from that. This is the agreement, lordship. If a buyer cancels or returns an order after 14 days of placing the order.
See, just a moment, this is NI case.
Yes, yes, sir.
We will agree the appeal,
Lordship,
but you'll have to pay the 20% deposit.
Lordship. Certainly, lordship. Lordship, may kindly allow me to stay in previous bill, lordship. I'm already on previous bill,
We will gain.
lordship.
How much?
1,30,000 has been fine and 1 year imprisonment, lordship.
20%, no, because it is 20%.
20%? Up to 20%. That is the decision of the honorable court, lordship. Considering my financial condition, lordship, kindly pass the order. Not in that sound financial condition, Lordship.
What is the prayer in the eye?
Prayer in the IA is to allow me to continue the previous bill and stay the operation of the impugned judgment, Lordship. Page 104, Lordship will find the impugned judgment in page 118, Lordship.
There are two judgments,
Lordship.
two judgments.
Yes, yes, yes. Two independent case. There are two judgment passed by the trial court, Lordship. Then we went to the first appellate court. First appellate court has upheld the judgment of the trial court. And punishment is for 1 year, Lordship.
In
In the IA, we have
Mr. A. Bhattacharjee for the applicant who has filed his application to IA to B1 under IA 127. Under section 430 of the BNWS with prayers to remain on previous.
previous bill, Lordship.
As the applicant has been, applicant has been convicted under section
138 of the
138
negotiable
of the
instrument.
NI Act, in connection with NI case number 17/22. And this conviction has been upheld in criminal appeal number 19 of 2025,
Lordship.
while order dated 26/9/2025. The they submitted that there is every, they submitted that the applicant, the stroke applicant has a good case and previous bill of previous bill has a good case, and there is every possibility that he may be acquitted from the charges which are. Considering the submissions, the and after going through the impugned judgments, the appellant is allowed to remain on previous bail until further orders. In terms of the above observation, this application stands disposed of. Further orders.
Sentence to be suspended, Lordship.
Suspension. This prayer is for suspension also.
Yes, Lordship, it has to be there.
The
We have prayed, Lordship, for suspension of sentence, Lordship.
conviction and sentence dated 26/9/2025 in
Criminal appeal number 19/25, as well as
the 17 the order of conviction and sentence in NI case number 17 of 2022 and the order in criminal appeal number 26/9/2025, criminal appeal number 19 of 2025 dated 26/9/2025 remains suspended until further orders.
I'm deeply blessed for that.
In terms of the subject until further orders, subject to the condition that the appellant deposits 20% of the this will be fine amount before the learned trial court within how much time is it? 2 months.
But maximum
is
is 2 months, but Lordship will 1 month. We'll do it in 1 month, Lordship.
Within 1 month from today. Actually, I think 2 months is given. I think we have to go to the act. I have forgotten. In terms of the above, we can this application steps disposed of.
Once কিনা যাই না তো
It will liquid, yeah. Appearance, and that council mistake here, but if is present for the applicant. You should notice the respondent returnable within 4 days. Call for the, records of
Yes, your lordship.
original records of criminal appeal number 19/2025 and miss case number, CR case number,
NI Act case number lordship 17/20
and NI case number 17/2025
22.
from the respective courts.
lordship.
List accordingly.
Item 8 is also same lordship. Same court,
But different judgment.
different judgment.
এখানে order repeat বা খালি হে তুমি appeal নাম্বাৰটো চাই ল'ব লাগিব। আৰু প্ৰথমতে তুমি NI case
NI Act
number
is
লিখিব লাগিব।
18/22 lordship.
পাৰিবা? কৈ দিম। পাৰিবা যদি মোক তুমি কৰিব পাৰা, try কৰিব পাৰা। Try কৰিছোঁ।
Diplomat. Only the date of judgment is different lordship.
Case number is like- Case
Ca-
numbers are,
Case numbers are different and date of judgment is different lordship.
date of judgment is different.
Diplomat.
Wait, please, Lordship.
Yes, yes.
A revision has been preferred against judgment and order dated, Milord. 12/11/2025, Milord, passed with the learned additional session judge Dibrugarh, Milord. Whereby, Milord, I was acquitted in a GR case, Milord. Appeal has been preferred by the complainant. And there they have, Milord, set aside the orders of, Milord, of my acquittal, the orders, Milord, on the ground that it has not been, the appreciation of the evidence has not been discussed with Milord. Milord, if your lordship kindly see the appellate judgment, Milord, which your lordship, just 3-page judgment on this, Milord. Page 44 onwards, Milord, it has been says, upon perusal of the impugned judgment and the entire records, it appears that this court, the assessment made by the learned trial court is very narrow and confined. The judgment does not reflect proper appreciation of the oral or documentary evidence available on the record. It is observed that there is no elaborate discussion of the testimony. What it said that there is no elaborate discussion of the testimony of the PW's, Milord. So accordingly, this is the next 45, Milord, that has been set aside, Milord, and has directed to appear before the trial court, Milord. Now, if your lordship kindly see the trial court judgment, Milord.
You are aggrieved by the order of.
Appellate court, Milord.
Appellate court. He was
Appellate,
acquitted.
I was acquitted, Milord. Now, the opposite party, there is a complainant, Milord, under 372, Milord. They have preferred an appeal against my acquittal, Milord. And appellate court, Milord, set aside the order of, Milord, acquittal, Milord, and
Convicted you.
not convicted, Milord. Milord, remanded back, Milord.
Or remanded back.
Remanded back, Milord. 46.
This case has been remanded back.
Remanded back, Milord. Milord, what is the only ground for remands? They have set aside, means acquittal order has been set aside and remanded back to hear a fresh, Milord. Meaning thereby, Milord, you are again going for a different orders, Milord.
You are filing a revision petition. Revision petition.
My lord, now if your lordship said the ground of, Milord, appeal and discussion of the appellate court was this, it was that the appreciation of the evidence has not been discussed, Milord. Milord, if your lordship kindly see, elaborately, Milord, discuss, Milord.
You are asking for a stay.
My lord, of appellate court, Milord.
So we will hear him only
Oh, yes, Milord.
because we'll hear you.
Now, as part of my lord, appellate court, if it is this appreciation of the evidence is to be done, not been done in a proper perspective manner, but if you, it is page 44, page 45,
Yeah.
will tell me. Upon perusal of the judgment, entire record of the trial court, assessment made by the learned trial court is very narrow and confined. That is 44, page 44. And the judgment does not reflect the proper application of oral and documentary evidence available on record. It is observed that there is no elaborate discussion of the testimonies of the prosecution witnesses, nor the submissions advanced by the learned counsel for both sides. The reason portion of the judgment is restricted merely to a single paragraph in which trial court summarily concluded that prosecution failed to prove the case beyond reasonable doubt. Thus, a conclusion without detailed analysis or discussion of evidence cannot be treated as judicial finding based on due appreciation of material evidence in a criminal trial, especially when allegations are under section and both the court is expected to discuss the testimony of material witnesses, examine their credibility, evaluate whether ingredients of the allegation and proof. Absence of such analytical system renders the judgment incomplete and unsustainable in law. Therefore, impugned judgment suffers from procedural legal infirmity in as much as the evidence has not been informated in proper perspective. A trial court has failed to assign cogent reasons for accepting or rejecting the testimonies of material witness. The matter accordingly requires a fresh adjudication by the learned trial court. On full and fair consideration of evidence and after affording both sides the opportunity to advance their arguments in detail. There is an order only for re-appreciation of what is there in the evidence. It is not needed for retrial or whatever.
No, they cannot be a de novo trial, my lord. They cannot be, my lord. Well, appreciation of your lordship, kindly see from page 20 onwards, my lord, whether all the 8 witnesses have been discussed with you. Whether it has been discussed on a by page of only 1 pages, my lord, they have set aside, my lord. Your lordship, kindly see page 20, my lord. Page 20 of the trial court judgment, my lord.
No, this is not de novo trial.
No, no, my
It's
lord.
only
No, no, what
remanded
my learned friend has said, that is why I say, my lord, there cannot be a de novo trial, my lord. It has to be appreciation is what, that whether the trial court has appreciated the evidence or not, my lord. Lordship, kindly see page 20 onwards, my lord. 8 witness has been trial court. In 1 page only, said that there is no appreciation of evidences. Now, if your lordship kindly see from page 20 onwards, my lord, discussion, decision and the reason thereof. PW1, my lord, this is about all the witnesses has been discussed with. Till page 31, 33, 34, my lord. From 20 to 34, 14 pages, my lord. The entire evidence has been discussed with. Then there is a finding, my lord, after discussion with this. So at this stage, my lord,
No, this evidence has been discussed, but it has to be appreciated also.
no, no, here only in the paragraph itself, my lords, it has been there appreciated, my lord. In the cross examination, it has been said, my lord, your lordship kindly,
We'll read them. Let's read
my lord,
from evidence,
page 20 onwards, my lord.
from discussion, yes. You can ask her to read.
No, I can, my lord. It is Sri Mongol Bhattacharya deposing as a PW1 in his evidence in chief. He stated that he filed this case again, accused person, and stated that incident took place on 4/4/2018 at 9 p.m. At the time the incident he came out from his house of the accused Bhogatos Banerjee is adjacent to his house. There is a CC camera on the roof of the accused Bhogatos Banerjee. The house of the Mrinal Kanti Bhowal is situated in the southern side of the Bhogatos Bhattacharya. PW1 stated that the accused Bhogatos Bhattacharya has installed the CC camera by facing the house of the Mrinal Kanti Bhowal, from where his house is visible, including the bathroom. PW1 has stated. In the night of the incident, there was a quarrel between the accused Bhattacharya and Mrinal Kanti Bhowal. PW1 gone stop the quarrel. However, the accused Bhogatos Bhattacharya has abused and seized him. Thereafter, PW1 came to his house on 5/4/2018. Accused has stated to abuse him and his wife. Again on 6/4/2018, abused him. On 7/4/2018 at about 3:30 p.m., the accused Bhogatos Bhattacharya had abused him and his wife by shouting that, "Tohot do you bahirale ula, tohotok kutithom." On 7/4/2018 at 7 p.m., the parents of the Bhogatos Bhattacharya had entered into the house of the complainant. At the time, door of the house was open and started to assault them. PW1 has stated the accused Bhogatos Bhattacharya has tried to outrage the modesty of the wife, Onu Bhattacharya, and also snatching her gold. On hearing hue and cry, the neighbors came out to their house, and above mentioned accused person went from the house. The complainant exhibit 1 is the Ejahat and exhibit 2(1) is his signature on it. PW1 further stated that after filing of the Ejahat, when he returned to his house, on the way, accused Bhogatos Banarsi abused him by saying that the Tohotor Bacha Dai, Nohot Ghoinet Murusole Potaibi, Moi Bacha Koridim. In his cross examination, now your Lordship kindly see the cross examinations. The accused Ejahat was drafted in a shop near the In the cross examination, the entire thing has been discussed with Milord. So that's how Milord, all the witnesses, Milord, so for the PW8, PW1 is the main is the informant, Milord. So therefore, Milord, your Lordship may kindly call for the records, Milord. Lordship will from the records kindly see that whether there is an appreciation of evidence or not. Milord. And in case of an acquittal, Milord, the scope is a very limited, Milord.
Please sit down. The judge is so right.
My Lord.
It's correct. This is only cut copy paste of the evidence recorded. And she has not discussed.
My Lord, that's right, but
She has not discussed why she is acquitted.
my Lord, definitely, my Lord, if you are a judicial determination, my Lord,
It's
my
only
Lord,
cut copy paste of the, she must record the reasons why she is acquitted.
my Lord, page 35, my Lord, it has been stated, my Lord.
Cut copy paste of whatever recorded in the, whatever she has recorded in the cross examination and in the evidence in chief.
My Lord, the 24, you said, I have, while discussing, my Lord, the evidences, my Lord, evidences while quoting, my Lord, he said that I have considered the evidence on record of the prosecution in entirety and in relation to the
That
instant
cannot
case.
be.
That, my Lord, but the evidence of the so-and-so has been, my Lord, is placed.
Whatever she is thinking, she has to express.
My Lord, definitely, my Lord, my Lord, it's a question of an, my Lord, appeal, why, because it's a case of an acquittal, my Lord. Now, on the basis of,
Maybe, but she must record the reasons why.
that's the, but
He will be
here,
acquitted.
here, my Lord, is
He'll be acquitted
paragraph 24, my Lord, paragraph 24. The conclusion was this, after discussing the evidence on records, my Lord.
Cannot admit it at all. Cannot admit it.
My Lord, I'll satisfy, I'll satisfy your Lordship may kindly post it, my Lord. Lordship may kindly see, the whether, call for the records, my Lord, kindly see, my Lord.
Not required actually.
My Lord, that is a reflection, my Lord. I also know that so much judicial determination is concerned.
We'll fix another date then.
My Lord,
I'm not issuing notice.
my Lord,
We'll fix another date.
my Lord.
My Lord, 312 is the my Lord, direction given to both parties before trial.
That will,
So let's fix another, 312.
On 312, this 312.
It's okay. Actually, I am not inclined to admit. So let's fix another date.
My Lord.
Learned Senior Counsel, Mr. P. Boy is present. Learned Additional 50, Mr. MP Usam is present. List this matter on 12 December.
My Lord.
I can say.
May it please, my Lord. My Lord, I'm preferring this present application on being aggrieved by an order dated 25/6/2025, my Lord, passed by the learned Chief Judicial Magistrate Majuli, my Lord. The facts of the matter is that, my Lord, I have lodged an FIR against the present respondent, which was registered, my Lord will find it page number 16, which was registered under section 69 of the BNS, my Lord. Thereafter, charge sheet was being filed. And in the meantime, the respondent also was arrested, my Lord. He was released on bail thereafter. After
Video off করে দিও। please, what is your prayer?
He signed a bond amounting 50,000 for a year, for 1 year under section 126 of BNSS, agreeing to maintain peace and public tranquility. Fellowship, apart from that, there was an observation regarding the actual ownership of the property also. This order was challenged before the learned additional session judge Nagaon. That order is on page 16, Your Lordship. The learned or the additional session judge was pleased to set aside this order, Your Lordship, on the ground that the executive magistrate do not possess the power. Actually, I am only as regards section 126, page 16, Your Lordship. The operative part is on page 25. The criminal revision is allowed on contest. The impugned order dated so and so, passed in so and so is incorrect and against the provision of law, and accordingly the same is set aside. If the whole order was set aside, my only prayer is that only as regard the signing of bond on apprehension of breach of public peace and tranquility, that part may remain, Your Lordship. Because the petitioner is dispossessed and there is every possibility that some fight may.
You are the second party in the original case.
I am the first party.
First party in the original
on
case.
the original
So
case.
you were dispossessed by the second.
By the second party.
So there was an order and both of you have signed a bond.
Signed a bond.
Both parties have signed a bond to maintain peace.
Peace. And that
So
was,
that the second party preferred this appeal
they preferred this appeal.
and the order has been set aside.
Set aside. Your Lordship, in that order, only the second party was asked to sign the bond. After perusal of the all the record and examination of the witness, the learned executive magistrate found that there is every possibility of breach of public peace and tranquility. So the second party was asked to sign a bond, and the whole order was set aside, Your Lordship.
You are only concerned with the bond, it will not work. You will have to see the bond is incidental to that order.
Lordship.
So if the order stays, then the bond will go.
Now, only as regard to the signing of the bond, because the fact remains that there is apprehension.
Order has to be set aside then. We cannot deal with the bond. The order has to be set aside.
But
This petition is under which section?
But under 126, the magistrate is empowered to sign the bond between the parties.
Yes, you can sign. See, the entire, you are agreed by the order. So that entire order, if you challenge, then this, your prayer will work.
No, we are challenging the whole order, Your Lordship. But
Only bond, one part if you challenge, then this prayer won't work.
no, we are challenging the whole order, but as regards stay, Your Lordship, the only.
Entire procedure, entire order should be stayed.
Stay.
There is possibility, man.
The,
So, actually, whatever, there is every possibility of breach of, because if one party goes there, and there obviously there will be a fight between both the parties. So, at this stage, I pray, status quo as regard to the and signing of bond, the order may be remain, my lord. Status quo may be there. Lordship may issue notice, my lord. No, my lord. And in that way, my lord, nobody will be prejudiced, my lord. Because that order, the executive magistrate has committed no wrong, my lord, because he found something on police report, on the basis of police report, that he has asked the parties to sign bond, my lord. So there was no wrong, my lord, subject to lordship's correction, my lord. And my lord, this order may be stayed at this, my lord, and my lord, notice may be issued, my lord. So my lord, let them appear, my lord. Lordship knows the executive magistrate, earlier 107, now 126, my lord. He has the power to compel parties to sign bond. That too, he has my lord, passed a regent order after going, do the police report, after going everything, my lord. Status quo, my lord.
Criminal proceeding.
Then, my lord, no, then, my lord, lordship may stay that order, my lord, the order of the learned session judge, my lord, who has the operation of that order may be stayed, my lord. At this stage, my lord.
let us see the reasons what the session judge has discussed.
Page 16, my lord.
Hmm.
Yes, my lord, he has stated that, my lord, the learned executive magistrate don't have the power, my lord, to pass such an order, my lord. But my lord, the lordship knows, my lord, section 126, earlier 107, my lord. Lord, the executive magistrate, my lord, he has the power. He has only asked the parties to sign a bond, my lord, that much. Well, nobody will be prejudiced, my lord, if this order is.
Please read the from discussions. Please read from discussions. Let's see.
The discussion, decision, and reason thereof. That paragraph 8, my lord.
Hmm.
The impugning order dated 9/1/25 passed in case number so and so is required to be examined for its correctness, legality, and propriety. TCR reveals that basing on the petition filed by the OP number 1 and after receipt of the police report, my lord, 107/144 CRPC, and proceeding under 107, now 126 was drawn up and directed both the parties to show cause as to why they should not be asked to execute bond. The EM went to record the evidence of both the parties, and after hearing both the parties, the EM Nagaon passed an impugning order with a reason as mentioned therein. For a magistrate to get a jurisdiction, take up proceedings under 163 BN, he must be satisfied that it is concerned urgent case in nuisance or danger, empowering him to issue a written order to prevent danger of human life, health, safety, or to prevent a riot or affray. Whereas to start proceedings under 126 BN, the magistrate has to be informed that a person was likely to commit a breach of peace, and in the opinion of the magistrate, there was sufficient ground for proceeding the proceeding. The difference between 126 BNS and 163 BNSS is firstly that under section 107 1/126 there need to no dispute relating to land and proceeding in is started against a person who is likely to commit breach of peace whereas under 163 BNSS 144 in cases where there is sufficient ground for proceeding and immediate prevention of speedy if desirable. Such magistrate may written order stating material facts of the case and served in the manner provided by section 153 direct any person to abstain from certain act or to act certain order with respect to certain property in his possession. A bare perusal of the proceeding in MR case number so and so would show that the learned EM Nagaon, while disposing the said case, nowhere recorded his or her satisfaction that despite likely to cause breach of peace exists concerning the disputed land passage. A bare perusal of the impugning order would reflect that the learned EM has not properly appreciated the scope of section 126. This is the matter. So he has, on the basis of police report, on the basis of everything, he has passed a reasoned order, but the learned, the session judge, he has stated that it was not a reasoned order,
Please sit down. Please sit down. No, there is no infirmity in the order. No infirmity in the order of session judge.
My lord, but my lord, the learned executive magistrate, he has the power, my lord. He has the power to
He has the power. He has the power to execute bond also.
lordship, but only that order he has passed, my lord. And they have come against that order. If my lord, lordship may kindly see lordship, my lord, if two parties goes there for a there is every possibility of my lord.
Why don't you go to the civil court, obtain an injunction?
My lord, that is there, my lord. But regarding this, my lord, this quarrel, my lord,
See, he really decided this matter like a civil judge.
no, yes, lordship is correct, but we have come against the order of 126, my lord, which was learned executive magistrate. He has passed, my lord. No, man, executive.
Yeah, he's decided this matter like a civil judge.
My lord, no, my lord, he has only asked the parties to sign bond, my lord.
So that sessions court, while deciding the case, has given the reasons that there appears to be nothing, not a hint of breach of peace.
My lord, it was based on a police report.
Where's the police? report?
But police, my lord, it
No, see, we are even recorded reasons, no? That there is a scope of breach of peace and public
yes,
tranquility.
he has sought for a police.
No reasons have been recorded. He is going ahead and he is deciding that he is the owner of the land.
My lord, that part, my lord, I'm leaving to.
Why don't you bring up a civil suit? If you are dispossessed, I think civil suit is the best way.
No, my lord, now, my lord,
Go about.
now we are not on that. We are only on the bond, my lord. We are only on the bond. We are only on the bond, your lordship. My lord, only on the bond, my lord. If my lord, if my lord, only on the bond,
Okay, then let us call for the records. Let us first call for the records.
lordship, lord,
Yes.
my lord,
No. Let us first call for the records.
lordship may call for the record till then the order may be stayed, my
No,
lord.
how can I?
Because my
call
lord,
for the first
lordship may
records?
see if one party goes there and
There is no breach of peace and
but
public.
there is every
Nothing is
possibility.
recorded
When
here.
there is a possibility, my lord, when there and
Why should I guess?
no,
without any
because
record?
in the when there is, but there is every possibility, my lord. There is if one party goes there only till returnable date, my lord.
This is the finding of the court.
My lord, but that was also a finding of an executive magistrate court, my lord. But
That is what I'm saying.
yes,
It's the
my lord.
finding of the executive magistrate.
But
court.
he has asked only to sign bond, my lord. He has not given possession to anybody, or he has asked the parties to go for a civil suit. But regarding signing of a
Let us call for the records.
record, lordship may call for the record.
If you have a case, we'll set aside.
But my lord, lordship may call for a record. Till then, my lord, this order may be stayed, my lord. Because my lord, there is every possibility of, my lord, nobody will be prejudiced if this order is stayed, my lord. But if something, if it is not,
No.
the both parties will against,
Not
they will go there.
orders cannot be stayed. You have to have a private case. To stay the order. you
But
have to
my
have-
lord, lordship may see, my lord, the order of the executive magistrate, there was no wrong, my lord, because he
No,
has.
he has not mentioned there is breach of peace.
My lord, but he has mentioned, my lord.
Where?
Yes.
Show me.
Page 14, my lord.
Please read.
Based on the evidence.
Please read.
My lord, page 14, my lord, bottom. Based on the evidence presented and the statement of the witnesses, this court concludes the following. The first party did indeed have a house on the disputed land, which was built under the government scheme approximately 15 years ago. The first party did not reside in the house regularly, often staying outside his village. The first party and his family members did not sell their land to the second party. The second party took advantage of the first party that forcefully occupied the house and dismantled it. It is true that the second party is now engaged in farming. I mean, these are the reasons. There is.
He is deciding this case like a civil judge.
But that man, I am also admitting it may be wrong, my lord. But my lord, but I am not on the right tackle of it. I am only that, my lord, if one party goes down, there will be quarrel.
I'll give you a short date.
My
We'll
lord,
call for the records.
but
and
till
we'll
then,
decide on instantly.
my lord, till then this order will, because my lord, this signing of
my lord, the bond, my lord, only on that part, that person, that part, my lord. Signing of bond, my lord,
No, no.
let it be there, my
You
lord.
cannot take protection in that manner.
Oh, my lord,
There has to be a prima facie case to stay.
but there is, my lord, he has given reason, my lord, that.
He has
he was
already
disposed-
started farming, you see, the second party had already dismantled your land, dispossessed you.
But now, if the first party goes there, there will be, if there is no maintenance of peace and tranquility, there will be, again quarrel, my lord.
That magistrate will decide.
My lord,
When there will be breach of peace and public tranquility, magistrate will
But he,
decide.
if, because now his order has gone, my lord, because his order has been set aside. Now, how can he decide, my
No,
lord?
I cannot decide.
No,
I cannot
that's why
mention breach of peace and public tranquility now.
No, no, my lord, the only thing, my lord, that should be maintained, my lord. Only one line that my lord, the.
I'm telling you, we'll give you a short date, we'll call for the records. This is from which place? Koliapur.
One minute and
We'll call for the scan copies. It will be better, we'll call for the scan copies of that, we don't want the district judge's records. We'll call.
No, man, I'm only on that's
That's what I'm
signing
saying,
of
we'll
bond,
call
my
for-
lord.
I will dispose it on the first day itself. We'll call for the scan copies of the records. We do not want the original because once we call
Oh,
for
but
the original.
till then, my lord, till then, the date may be.
You have to have a prima facie case, you see.
But my lord, there, if lordship may kindly see, my lord, these shows, my lord, there is every possibility of my lord, the breach of peace and.
Why it has not been mentioned in the order then?
He has given categorically given some reasons, my lord. Page 14 that they were there, they were dismantled is out.
Let us read the entire order then. Let us read the entire final order.
And final of the executive magistrate, my lord.
From the beginning.
Case summary. My lord, a petition was filed by the first party against the second party. A police report submitted by the officer in
Just
charge
a
of.
moment, I'll come back to you after 5 minutes.
Lordship.
5 minutes. Please.
My lord, before coming to the order, my lord,
Yes.
may I take my lord to my lord, the section 126, my lord. 126, lordship knows, my lord, that.
126 of
Well,
PNSS.
BNSS, my lord. Earlier 107, my lord.
No, I'll just go through the judge, the order of the judge.
Lordship.
That those sections are known for me.
No, lordship, no, yes,
This
my
is
lord.
only change of names.
Names,
Say numbers.
numbers, my lord. But my lord,
Please read the final order.
final order, my lord. The final order of the executive magistrate. A petition was filed by the first party against the second party. A police report submitted by the officer in charge of so-and-so police station to provide non-FIR number under section 126, 163 BNS at the Ambagan PP. Non-FIR case number 15/24 under section 126, 163 of the BNS. The case was forwarded to the co-district commissioner, Koliapur, to the court and the undersigned for disposal. The brief of the case, my lord. The first party and the second party are the residents of so-and-so. The first party previously owned the actual ancestors' land in Pata number so-and-so of Pub Larimukh Kismat under Laukwa Moja, Samuguri Revenue Circle. The first party family sold most of their land to the aforementioned Patas, and the second party retaining only few parcel of the land. Only these parcels, dark number so-and-so, the first party built at Indira Awas Yojana house. However, the first party did not regularly occupy the house, staying there only once or twice every few months. The first party alleges the second party taking possession of his absence illegally entered the land, demolished the house, and forcefully took possession of the land. The first party further claims that the second party has been threatening him with dire consequences should he be attempt to re-enter the disputed property. The second party denies the allegation, ascertaining that the first party sold all their land to them. The second party also contended that fallen tree Storm destroyed the house. A case concerned for a forceful disposal of land and property which involves a breach of peace and public tranquility. It was pursued under section 126 and 163 BNSS. These are statements, submissions and statements of my lord. And Lordship knows, my lord, that 126, my lord, if the magistrate is satisfied, my lord, then he can ask the parties to sign bond, my lord. The reasoning possibly, my lord.
Please continue.
My lord, the witnesses, my lord. My lord, we witnesses, my lord. PW1 Mokbul, son of so and so, Larimuk stated that he allotted a government house to the first party in 2009-10 when and he was a panchayat member. The house was built 15 years ago. PW2 Narayan Sarkar, who testified that the house existed on the disputed land for 4 or 5 years, but in the last 2-3 months he has not seen the house. Then Ranjan Sarkar confirmed that the house existed on the disputed land for the past 10-12 years. The house was constructed by the first party, who did not reside there regularly. He was unaware of the cause of the house demolition. Then PW4 my lord, stated that half of the family lands were sold to the second party, while the remaining land was retained by the first party. He claimed that disputed land covers approximately 2 acres, and the first party had been residing in the house for about 13-14 years. Upon visiting the property in March 24 from Bengal, he was denied entry by the second party. He further stated that the house had been partially damaged by storm 5 years ago. Then Ashok Chakdhar, my lord, so and so confirmed that the disposal land measuring around 2 acres was not sold to the first party family. The first party constructed Indira Awas Yojana house on 2009-10. The second party took advantage of the first party's absence and forcefully occupied the land. Then PW6, my lord, Ahmed Ali, disputed land belongs to the first party and the house was situated on the land. The second party demolished the house in February 2024 using JCB machine and has since taken possession of the land. Then Suleiman Ali Malad confirmed that the existence of the house of the disputed land and that the first party was the owner of the house. He stated that about 7-8 years ago, a tree fell on the house, which eventually led to its demolition. The remains of the house are still present. He mentioned that the second party was farming in the disputed land. Then another malad, DW malad, they testified that she had earlier resided in the house of the disputed land, which is constructed by the second party. The house was demolished a year ago due to fallen trees. She also mentioned that she had been living in so and so for the last for past year. Then another DW malad stated that he was aware of the existence of the house at a disputed land. The house was demolished 1.5 years ago due to fallen tree. He confirmed that the woman.
Okay.
Lordship may kindly, Lordship
Call
knows.
for the records.
Lordship, call for the records, man.
Record and dispose it, finally.
Notice may be issued, but my Lordship knows 126, my lord.
He can pass an order.
But my lord, the Lordship knows, my lord, there cannot be, there may not be any reason also, my lord, if he is satisfied.
See.
126, my lord.
Not required actually. And this land appears to be that second party's land only.
No, but
I
some
mean, land appears to be the.
first parties.
No, first party's land.
House was there.
He sold his entire land to different purchasers. Let's see. Let's call for the record. Maybe he has a house of Indira Awas Yojana. Maybe he had a house. but that wall has also been demolished. Learned item number 11, no? Learned Counsel Mr. Yasam Abdullah P is present for the petitioners. Issue notice to the respondents returnable within 2 weeks, or should I give you a date?
Lordship may fix a date.
Date the leader from 12 December.
12 December.
Meanwhile, call for the scanned copies of the records from the executive magistrate immediately of MR case number. Executive magistrate Kodiabor, no?
Koliabor, my lord.
Immediately of MR case number
323/24.
323/24. As this is an urgent matter, list.
May please, your lordship. Here in this case, what has happened, my lord? The informant is illegally occupying the rooftop of the school of which the petitioner is the president of the school management committee. And in spite of the order of the removal of her school, my lord, and in spite of the order passed by the learned district magistrate as well as the mission director, Sarva Shiksha Abhiyan, she started contemplating permanent structure over that illegal school. So we lodged an FIR. Against that counter FIR, she lodged an FIR and police has submitted the charge sheet. We have come against that only. And in this honorable court, earlier the headmaster cum secretary has also approached before this honorable court against the passing of the same proceeding, my lord. And by order dated 2011-25 passed by this honorable court at page 45, my lord. The further proceeding has already been stayed. The similar order may kindly be passed. This is totally a civil suit.
Page 45.
Yes, my lord. This is the order. Civil dispute and as a counter to my FIR and taking action against the illegal occupied school by the informant.
Same school.
Yes, my lord. Page 45, my lord.
Page 45, same school.
Same school.
The petitioner was headmaster.
This present petitioner is the president of the management committee, school management.
Earlier president.
He was the headmaster cum secretary of the same school. The removal order is at page 21.
Mr.
G. Jalan, my
G.
lord.
Jalan, counsel for the
Petitioner.
petitioner, Ritesh Bowry, who has filed his application for quashing the order dated 2/6/2023 passed in TRC case number 820 of 2023 by the judicial magistrate first class number 4 Kamrup Metro. Administered. MP Goswami, learned additional PP Assam for the respondent state. RR Kaushik. I didn't see when they be turned up. RR Kaushik, learned additional PP Assam for the respondent state. Sama, who has accepted notice on behalf of the state of Assam. Full stop. Extra copies to be furnished. I think one stay has already been granted.
Yes, similar. By.
We'll rely on that and grant the stay. You have
Always.
any objection? No.
TRC case number 820/23.
Petitioner to take steps to issue notice to the respondent number 2 returnable within 4 weeks. Also call for the scan copies of the record of PRC case number 820/2023. To start earlier this proceeding against the headmaster Sri Lalit Kumar Jha.
Yes, ma'am.
Has been stayed by the order of this court in criminal petition 1458 of 2025 within bracket annexure 8 bracket close by the order dated 2011-2025 passed by a coordinate bench of this court. Full stop. It is submitted that false allegations have been brought up by the respondent number 2
Please.
against the present petitioner, who is what is the petitioner?
President of the school management committee
President of the school management committee.
of Rashtra Bhasha Prabhagar Hindi MEN LP school.
how, against how many they?
Two, only two accused.
It appears that, what is the respondent, what is the allegation against the respondent?
Respondent, my lord.
Respondent number 2.
She is the headmistress of another school, Rashtrabhasa Prabhagar Hindi High School.
Submitted that the respondent number 2 is the headmistress of another school and not the school presided over by the present petitioner. She is the president.
No. She is the occupying the rooftop of the school of the present petitioner's school by the name Rashtrabhasa Prabhagar Hindi High School, whereas the president is the president of the management committee of the Rashtrabhasa Prabhagar Hindi ME and LP school. That is the difference. That is the high school.
It is submitted that the respondent number 2 is illegally occupying the rooftop
Rooftop of the Rashtrabhasa Hindi,
of the Rashtrabhasa
Hindi ME and LP school.
ME and LP school, whereas
Whereas-
she is the,
She is running a school by name Rashtrabhasa Hindi High School,
whereas she is running a school by the name of
Private school.
Rashtrabhasa
Prabhakar Hindi High School.
Prabhakar Hindi High School.
Yes, ma'am.
Full stop. It is further submitted that, it could লিখা হল না, বেলেগ স্কুল বুলি আগতে লিখা হয়. It appears that there is a prima facie case to stay the proceedings against the present petitioner, thereby the proceedings of PRC case number 820/2023 is stayed till the next date of listing.
Well, the warrant of arrest has also been issued by the same order, page 46. The same-
Warrant-
Yes, my lord, subsequently warrant of arrest has been issued on 17/11. So we have appraised the court, but still since the filing slip could not be produced, only at ground, my lord, at page 46, para 6, my lord will find in the earlier proceeding.
We have prayed for stay of.
Yes, my
warrant
lord.
of arrest.
Yes, my lord.
We won't stay a warrant of arrest.
That may be kept in abeyance, my lord. Since this proceeding is stayed.
Yes, you want to say something? Hari?
You can appear there, and the protection can be given.
Since this honorable court is in session of the matter, further proceeding has already been stayed, so warrant of arrest may be kept in abeyance, my lord. After the disposal, if either way, if it is decided against me, I will appear.
The WA is default till the next date of listing.
Yes, madam.
You come, we'll fix it till the next date of listing.
Problem.
The NBWA is against the present petitioner is default till the next date of listing.
Obliged, madam.
Item 14.
May it please your lordship, in this case, we are challenging in the order dated 24/7/2024, your lordship, at page 33. Your lordship may kindly peruse. This is with respect to a proceeding under the Domestic Violence Act, your lordship,
Page 34.
page 33, your lordship.
33. Please read.
May I read, your lordship? Aggrieved Anu Kumari Singh has filed petition under section 120 of the PMB DV Act, seeking relief under section 18, 19, 20, and 22 of the Act against the respondents, namely Rahul Sai and Shakuntala Shah. The petition is
Instrument Act, my lord. A case has been filed against the petitioner, my lord. Case was proceeded on, and accordingly, my lord, matter was fixed for cross-examination at the PWs, PW1, and subsequently, my lord, the accused, that is the present petitioner, who was all along appearing, my lord, in the proceedings,
Wife was suffering from cancer, no?
my lord.
Yesterday you told me.
Yes, my lord. My sister-in-law, my lord.
Oh, sister-in-law.
My sister-in-law,
Sister-in-law was suffering from cancer.
my lord, subsequently died. For that reason, my lord, I could not appear,
If your sister-in-law is suffering from cancer,
my lord.
she is dependent on you. Is she married or unmarried?
And that is not that. So far, what happened, my lord, is the personal matter, my lord. In that case, my lord, the cross-examination has been conducted by me. And during that period, my lord, I could not appear because of the fact for attending medical, my lord, purpose, my lord. And subsequently, I was busy with the medical duties in relation to the treatment, my lord. So on that particular day, I could not appear, my lord. On that day, my lord, order has been passed. My lord, my submission before lordship.
The stay
Well, at this stage, madam, my prayer
You
is,
have to cross-examine
yes, madam, PW1.
without hearing the other side.
My lord, what happened, my lord, only for that particular day, my lord, the PW1 was not allowed
Only
to cross
for one date,
on that one.
only one date, okay.
He will not be suffered, my lord, because in 26 numbers of cases, my lord, only in 2 cases, my lord, this order has
Only
been
this
passed.
will, only this.
Others
we have
has
to
been, my lord,
go-
continuing, my lord, and we are conducting all the cases, my lord. Almost the, my lord, other cases cross-examination has been partly concluded, my lord. That is, some are, my lord, already disposed of. In 2 cases, my lord, we have been acquitted, my lord, out of 3, my lord. In other cases, everything is going smoothly, my lord. Only in 2 cases, my lord, we are facing problem. So for cross-examination,
So today we have 2 additional affidavit.
2 additional affidavit.
That which did not come up yesterday.
Yes, my lord.
And again, you have filed one new additional
New
affidavit.
additional affidavit in respect of bringing on record the medical documents, my lord.
In respect of
Bringing on record of medical documents, my
your sister-in-laws.
lord. The petitioner will not,
Where is the prayer?
my lord. Prayer is at my lord. Starts from page 57. In item number 37, my lord. Page 50, starts from page 57.
So you did not issue notice to the, all these dates, you did not issue notice to the respondent, number 2.
Number 2, my lord. My lord,
So
what
you
happened?
want to say something, state? Formal party.
My lord, if my lord, the further proceeding state, it will cause delay also, my lord, for disposal of the matter, my lord.
No, we will send it back. I'll pass a note and send it back. Six five 2024,
My lord,
21/6/2024, 26/7/2024, and 9/9/2024.
my lord. Thereafter, my lord, I have filed an additional affidavit yesterday that has entire case record has been, my lord, orders has been, my lord, annexed, my lord. Now matter is fixed on 4/12/2025 for SD, my lord.
You have brought this also on record,
My lord,
that matter is fixed for a statement defense.
my lord. Entire order sheet has been, my lord, annexed.
So this is your prayer. In which paragraph of your petition you have mentioned that there are 26 cases and all the cases have been
In additional affidavit, I have also
in
mentioned.
additional affidavit? Where is, which one?
Yesterday, my lord.
Page 144.
My lord, 2711.
Page,
Page 145, my lord.
page 144,
Paragraph 3, my lord.
paragraph 3. All right. And the order sheets?
Order sheets, my lord, starts from, my lord, page 148, my lord. Sorry, my lord, page 153, my lord. 53 onwards, my lord. 53 onwards, my lord.
Okay. Our learned counsel, Mr. M.K. Sharma, no?
My lord.
For the petitioner. Very,
Delivery of judgment, item number 1.
It is allowed, almost how much you have asked for? 8,43,504.
Item
That is-
number 2 for delivery of judgment.
Here, both are dismissed. Both objection and that appeal is also dismissed. Yes, both are dismissed. That order will be upheld.
Lost.
We have both opponents. And making a joint prayers, my lord. But item number 2.
Item-
34.
34.
34 years.
Not today, my lord, any other day, my lord. January.
In the month of
After,
January.
after.
Yes. As agreed by both the sides, list this matter on.
After Bihu, 20, I have already 2, my lord. Let it be 22. Oh, take it, so 22 will do. 22 तारीख.
Positively,
Ah.
positively on 22nd January as. this is a
22nd.
Pending matter.
Yeah. Much obliged, my lord. Obliged. 22 तारीख.
Item number 30 for hearing.
Your Honor, in the matter, 33, one death verification required. And the person was residing at Mumbai. Here-
33.
So the applicant has passed away.
Yes, lordship, 33.
This 33 and 32 is arising out of one judgment, your lords. This appeal is arising out of one judgment.
One judgment.
One judgment.
And the applicant has passed away.
Yes, one appellant, my lord.
Pass.
I am appearing Prasad Kumar Chandra. We have provided the death certificate, but they wanted to verify.
So his residence was shown as Dehradun. A person
Yes.
has gone to Dehradun, but daughter has said that the certificate will be available in Mumbai because death was. So that report we had. So let us verify from the Mumbai Municipal Department. With regard to that,
Daughter has said, no?
a daughter said that he expired at Mumbai.
Okay.
Report that the is in the Hindi.
He was 95.
Yes, 95, my lord. Still, if they want to verify, my lord.
Subject to verification, the
We
matter
need
may be fixed
we
for
need a
hearing
report from anybody, but that has to be
from the
in
municipal
writing.
department.
Anybody can give us a report. We abate the case, but that has to be in writing, that's it. If you want to verify, you can verify.
We have given the death certificate already. my lord.
Death certificate is with us, her daughter has given, his daughter has given us death certificate also. But
They
subject-
want to verify the death certificate.
but
to that
in
maybe.
one case it happened,
Ah.
person, person accused is,
97,
uh,
97.
not in this case, in another
In
case.
other case.
Accused is alive and the verification report has come that he is expired. So that is right, but in this case, he is
So nobody-
expired. Let the matter be fixed for hearing finally. Meanwhile, on the date of hearing, we will produce the verification report also. If at all required.
Actually not required, it is 97. But
This one I can produce before.
বিশ্বাস নকৰে ন চাৰ্টিফিকেটখন বিশ্বাস নকৰে বম্বেৰ পৰা দিছে নে মানুহ মৰিছে দেহৰাদুন দেহৰাদুন থাকে
But it's good now if it happens in real life. If somebody is declared as dead and if he's alive, it's really good.
Yes,
Fortunate.
yes.
But this doesn't happen in real life.
So if he is alive, Mr. Bora will be more happy because he'll get the fees for here.
At the 97, my lord.
97, he must do it pro bono.
Yes, pro bono.
It is number 33, no?
Let it abated.
Now,
I
item
have
33, no?
recently
Learned
revised
Standing
the
Council, Mr. M. Roy,
Yes.
and Learned Standing Council for CBI. Ms. M. Kumar is present and has submitted that. Submitted
This is
for
Hindi.
time
Said
to
I go through.
verify the death certificate of the appellant.
Shall I go?
Huh?
It is in Hindi. Shall I go?
No, but you are seeking time for verification?
No, let it be abated. Meanwhile, we will see in our own.
Okay, okay.
Let it be.
I can read Hindi. I can read Hindi.
CBI doesn't believe anybody, man. It appears that CBI doesn't believe anybody. Neither death certificate nor the whether Lordship can read Hindi or not.
I think I have not given the translated copy and the court language is English.
Yeah, it's
that
good.
is
If
why
you
I
can
asked.
read it out, it's good enough. Yes.
CBI don't even, my lord, CBI don't even spare the dead, my lord. They also trouble the dead.
Moral Pishat, we are not leaving.
No.
Spare me.
We told her that we are not going to spare it tomorrow. Before Lordship arrived, we had already told her that we are not going to spare you today.
Then, miss case.
Yeah, we can read that.
It's all right, only like it.
Abated, my lord.
It is last sentence is Learned Council means for CBI, Miss M. Sumari is present. Full stop. If the certificate was also earlier furnished by the appellant. You have given a death certificate earlier?
Yes, my lord.
Which page?
Death certificate is enclosed here with us in this page.
That the appellant has passed away. The Learned Council, Standing Council for the CBI has submitted that on inquiry, it was learned from the daughter of the appellant that the appellant, the daughter of the appellant, P. Kumar, Prasad Kumar
Chandra.
that the appellant has passed away. The death certificate of the appellant is also annexed, is also submitted. And this will form a part of the record. Thereby this case against, thereby this appeal against Prasad Kumar Chandra is abated. Send back the, we have the trial court records.
Yes, ma'am.
We have, send back the original trial court record.
Yeah, sir. Other appeal is there, madam. There is another.
The one appeal is,
There's another-
there is a connected appeal will remain, madam.
Item number 32 is connected. appeal.
Okay, okay. This is only one appellant, one. This case is abated, send back to Mahayo. Okay, Prasad Kumar Chandra, Ravindranath Mishra and all of them. You are what?
Srivastava, ma'am. PK Srivastava. Pawan Kumar Srivastava.
Learned Council, it will. Learned Council, Mr. P. Kotoki is present for the appellant. Learned,
That
you
will-
place your submission to the hearing?
Yes, but actually, there was direction for preparation of paper book. I have already prepared. Paper book, I am giving a copy to her also now. On last occasion, there was a direction, my lord. Yes, and also the code, my lord, for purpose of, because I have a record, I have kept.
Now you will place your submission or you will, she will take some time.
Time, yes, sir.
Okay.
After, you.
Learned Council, Mr. P. Learned Standing Council, Miss M. Kumari. Standing Council CBI, Miss M. Kumari is present and she has received the paper book.
Paper, it's a synopsis.
Synopsis for a paper book.
Immediate has come. Paper book you
This
can.
matter for hearing positively on. Any other day? It's okay. Positively. as
Because
it's
he also
been
91
25
years, my lord,
Huh?
92.
By the
Very aged person, my lord.
this inquiry itself done at the age of 55, I suppose.
Before retirement and then they have retired, then enjoyed their life and now
It is of the ONGC department.
they're enjoying their old age. It's good.
Yes, sir. He's also 92 years, but I've talked to him.
92.
Hmm.
এইটো record part of the record বুলি কৈছো না, record ৰাখি থৈ দিয়া।
Whether he will remember whether this case is pending.
No, no.
or that is.
About who could I think I'll talk with you.
Now, anybody, if the case goes against him also, if anybody wants to forward it to custody, nobody will take him in custody.
Actually, he doesn't have a case also, man.
But if it goes against him, nobody will take him in custody.
Custody also.
Police will also be hesitant, jail will be more hesitant.
Must be.
My lord, this criminal revision arises out of dishonor of a check wherein the petitioner was convicted and later upheld by the session court. Against revision, we have come. In the meantime, matter has been amicably settled between the parties. To that effect, a memorandum of understanding and a money receipt has also been executed between the parties, lordship. We have filed one additional affidavit to bring on record, lordship, the MOU as well as the money receipt that is possibly not on record. So may I pray next week, lordship? Matter has been settled between the parties. A Ganguly, yes.
Agent submitted, learned counsel Mr. A. Ganguly is present for the appellant and learned counsel.
Respondent number 2, Lordship.
Your name?
Just B Chetri, Lordship. Respondent number
B Chetri is present for respondent number 2 and is, and has, and is not again. So it is submitted on behalf of both the sides that the matter has been amicably settled. And this matter will be listed to place the memorandum of understanding.
Already filed, lordship, additional affidavit that is not on record. Let it come next week.
Okay, to কাটি আছো। Registry to place the memorandum of understanding.
No, lordship will
Registry
only
place the
refer additional affidavit.
Additional affidavit on record. Registry to place the additional affidavit submitted by the parties on record.
By the petitioner, in fact, filed by the petitioner,
Parties না লাগে রে, filed by the petitioner.
filed by the petitioner.
Okay, nice.
Public.
Complete, no?